Hello, everyone. Hope you're all staying cool today. Welcome back for another session of Keeping the Promise, Core Skills for Effective Land Stewardship, hosted in partnership with the Northwest Connecticut Land Conservancy. I'm Ricky Bentley. I'm the program manager at Connecticut Land Conservation Council. We're the statewide umbrella organization for Connecticut's land trusts. We're here to support your work through advocacy, technical assistance, and programs like this series. If you haven't already, I would recommend signing up for our e-news. It's a great way to stay in touch about upcoming programs. This program, we're focused on sharpening the practical skills needed to ensure the enduring integrity of our stewardship programs, helping all of us uphold that forever promise we make to the lands and our communities. As before, question and answer. We want this to be an interactive session. Please use the Q&A function at the bottom of your screen to submit questions. We'll have some time at the end to go through everything. And as with our previous sessions, today's is being recorded. The video will be posted to our YouTube channel for future reference. And then you all should have received an email from me, but last week's session that was canceled has been rescheduled for Tuesday, June 2nd, from noon to 1:30. Be the same link as the rest of the sessions. And that was the session on civil and legal recourse for encroachment resolution. So today's program, today we have Tom Kester from Terrafirma, who will be presenting on key aspects of Terrafirma coverage and what the trends can tell us. Tom, thanks for joining us.
Thanks, Ricky. Hello, everyone. Let me get my screen up here. Right. So, welcome. Today we're going to be talking about just Terrafirma trends. I'm very happy to be invited to be a part of Keeping the Promise series. A little bit about myself. My name is Tom Kester. I'm the operations manager and secretary for Alliance Risk Management Services. So my job is to run the day-to-day operations side of Terrafirma. That's handling applications and membership. I chair Terrafirma's members committee, which is essentially Terrafirma's corporate board. I oversee contractors, investment, audit, risk management, basically anything that's non-claims related sort of falls in my lap. I am an actively licensed Vermont attorney, and my background has been primarily focused on healthcare insurance law. I was a staff attorney for Vermont's Medicaid department. I was a private practice attorney as well, focusing on real property disputes, transactions, general civil litigation. And before joining the Land Trust Alliance, I was an assistant general counsel for an affiliate of a national healthcare insurer. Bad the ugly of insurance, and I'm very happy to be with the good insurance. I think that is Terrafirma. So I have just a little housekeeping. I'm going to be sharing my PowerPoint slide deck with Ricky CLCC. So please don't feel like you take copious notes with what you see on the screen. And as Ricky mentioned, there will be a Q&A at the end. So if you have questions, we have to decide some time to answer them. I don't know if Shelley Harms is on the call, but I just want to call out Shelley. Shelley, I think her reputation precedes her in the Connecticut land conservation community. She's involved with Norfolk Land Trust, Cornwall Conservation Trust, Salisbury Association Land Trust. But most importantly for this presentation, Shelley is the New England representative to the Terrafirma Members Committee. So she represents Rhode Island, Connecticut, Massachusetts, and New York land trusts who are Terrafirma members. So very happy to have Shelley as the representative. She's done an absolutely fantastic job. So if you want to learn more about Terrafirma and hear about what it's like to be on the Members Committee or just things about Terrafirma, feel free to reach out to Shelley as well. So the first part is just going to be an overview of Terrafirma. So Terrafirma was formed in 2011 to help land trusts defend their conserved lands from legal challenge. Terrafirma really came about its inception came about from the 90s when land trusts began to experience legal threats to their conserved parcels. And after a couple of decades study by land trust community with national insurance companies, as well as insurance attorneys and other land trust practitioners, it was decided that a national sort of captive insurance entity would need to be created to help the land trust community. And so that's what ultimately brought about Terrafirma. It was formed in 2011. It took a couple of years for Terrafirma to get all the regulatory stuff in place. It issued its first policies in March of 2013. Currently, Terrafirma issues policies to 572 land trust members in 48 U.S. states and the District of Columbia. It insures over 12.4 million acres. For a comparison size, that's about double the land mass size for the Commonwealth of Massachusetts. And since 2013, over 4,100 claims have been filed by Terrafirma members. And since 2013, Terrafirma has paid out over $10.1 million in covered claim costs to help defend its members against threats to conservation purposes. I think a really important thing about Terrafirma is that land trusts helped conceive, create, and design Terrafirma. Terrafirma is also owned and governed by its land trust members for its land trust members. So neither the Land Trust Alliance nor Alliance Risk Management Services owns or governs Terrafirma. Terrafirma, ARMS, the Land Trust Alliance are all separate legal entities. Who ultimately makes the decisions for Terrafirma are its 572 land trust members. So next is what makes Terrafirma different than typical liability insurers. I'm sure we all have experience with insurance companies and coverage and filing claims and all that. So you might have some preconceived notions about liability coverage. But I just wanted to tell you, there's a couple things that make Terrafirma different than your typical liability insurer. So first, that there's no filing penalties. So whether a member files one or more claims with Terrafirma, it will not affect your premium, your cost sharing coverage, ability to renew. What that means is please file claims with Terrafirma. If you are a Terrafirma member or if you're not a Terrafirma member and you're concerned that filing claims is going to have any adverse impact, there's no filing penalties whatsoever. We like to think that it's a member's job to be filing claims. If you're doing your job, you won't be penalized for it. So again, there is no financial penalties to filing claims. It won't affect your coverage, your cost sharing, your ability to renew. So we've had members who file claims who get covered. They get the same pricing, the same coverage, the same ability to renew as any other member. Low premium. So Terrafirma has only increased premium 4 times in its 15-year policy history by a whopping total of $13 per parcel increase. That increase over 15 years, which probably is way below inflation for that time. A lot of other insurance companies, it's not a matter of if they're going to raise premium, but by how much. And Terrafirma really tries to keep its premium low and cost effective for its land trust members. Terrafirma also is a nonprofit tax entity, just like your land trust. So it's not looking to profit, looking to just be able to cover, its known liabilities, cover expected claim costs, what have you. Next is members equality. So all Terrafirma members receive the same simple pricing and comprehensive coverage options. Terrafirma doesn't underwrite individual parcels. So it's not like this parcel gets that cost and that coverage, and this parcel gets that cost and that coverage. All Terrafirma members' parcels that get insured get the same comprehensive coverage. And last, certainly not least, is this unique coverage. So unlike some liability insurance, Terrafirma covers legal fees when land trusts need to take legal action, not just when they are sued or suffer damages. How terrible would it be if you had to wait until that threat actually materialized, that they were going to cut down the tree or move the earth or build that building they're not supposed to? So I like to think of this as sort of preemptive coverage. So when there's threats made against conservation purposes, Terrafirma's coverage can kick in to help defend against threats made. So, but it also applies too if you actually suffer damages, if you're handed a complaint, that sort of thing. Terrafirma's coverage can also kick into effect there. So the actual policy coverage itself. So Terrafirma sells just one insurance product, and that's called Conservation Defense Liability Insurance. And so what it does is it pays for certain litigation expenses when there are actual or threatened violations of the land trust's conservation rights of insured parcels. So you'll see there, actual or threatened, that threatened aspect, that preemptive coverage that can kick in. And so litigation expenses, what are we talking about here? So these are things like attorneys' fees, court costs, expert witness costs. Just to point it out, Terrafirma is not property insurance. It's not general liability. It's not title. It's not directors and officers. Terrafirma covers a specific gap left by these traditional insurance policies. So what Terrafirma covers is generally not covered at all by any of these other traditional insurance products. So Together with your general liability, director's property title, your other coverages, Terrafirma complements and fills that gap left by those other policies. And Terrafirma is an additional safety net. It's not a substitute for sufficient legal reserves and sound practices, which include immediately addressing all potential problems. Land trusts should think of Terrafirma as standing behind them to protect their resources from catastrophic legal expenses and to help them avoid unnecessary litigation through solid practices, early dispute resolution, and smart risk management. Like every insurance policy, Terrafirma's policy does include certain excluded items. For example, property damage costs, restoration costs, and land trust costs to respond to litigation. The hope is that if you have to be involved in a litigation matter, that your attorney would seek property damage and restoration costs to compensate you for the damage that's been done. But Terrafirma's insurance policy itself does not cover damage costs, restoration costs, as well as land trust staff costs to respond to litigation. So again, that's why it's good to have sufficient legal reserves and have money set aside to deal with those sort of things that are not covered by insurance or just ancillary to responding to litigation. So I do get asked sometimes, like, well, what exactly are we talking about threats to conservation purposes? So these are some broad categories that Terrafirma sees. And usually when a claim comes in, it gets assigned to one of these sort of categories. Boundary access, this is a vegetation cutting related issue, structures or improvements, division of partition, extinguishment, topography changes, also dumping, water rights, business disputes, wildlife issues. So for boundary access, what we're talking about here is boundary line disputes, not allowing monitoring access. If you have fence placed over property lines, you're mowing over property lines, creating, expanding, modifying rights of way, trespass and encroachment. So for vegetation cutting, talking about the threats of conservation purposes, removing or relocating plants and trees, illegal timber harvest. Conservation threats to structures improvements, we're talking about building outside of permitted building envelopes, building greater than square footage limitations, unpermitted structures and purposes. Threats to conservation purpose involve division partitions. So we're talking family trust, LLC disputes, and divorce. People might be seeking partition actions. We see division when landowners want to subdivide for economic gains. Extinguishment related conservation threats. We see challenging the validity of a conservation easement or a deed of restriction, or challenging the title itself, or saying that there's maybe deed superiority in the chain of title. Threats to conservation involving topography changes. We're seeing earth moving and grading. The other categories there are pretty self-explanatory: dumping, so organic and inorganic materials over property line by a landowner or neighbor. Water rights, that's more of an issue out on the West Coast, but we do have one covered claim on the East Coast involving water rights now. Business disputes, and then wildlife issues. So those are some of the just sort of broad categories that we're talking about, let's say, conservation purposes and the threats to them that Terrafirma sees and covers. So just to give you a flavor of what Terrafirma sees. Next, I want to move on just to Terrafirma eligibility. So if you are interested in joining Terrafirma, or if you're a Terrafirma member, you want to know what eligibility requirements you need to meet on an annual basis, there are 13 eligibility requirements that a land trust must meet to join and continue meeting every policy year. And in this slide, I have a link to the 13 eligibility requirements on the Terrafirma website, terrafirma.org. If you go under the info tab, you'll find a hyperlink to the eligibility requirements there. And there's more information on each eligibility requirement. And I encourage you, if you are interested in joining Terrafirma, to take a look at that link. But I want to call out 4 requirements in particular that are sometimes a stumbling block for land trusts to join Terrafirma. So the first is that you have to have complete baseline documentation on all parcels you're looking to insure. You must conduct annual monitoring on all parcels that you're looking to insure. You have to have general liability insurance. Directors and officers and title insurances are not recovered for Terrafirma eligibility, although it's good to have those. And the fourth is that you be a Land Trust Alliance member. Like I said, there's 13 eligibility requirements. These are 4 in particular that I see a lot of land trusts being stumbling blocks for them to join Terrafirma. Also, being accredited by the Land Trust Accreditation Commission is not an eligibility requirement for Terrafirma. If you are accredited, very likely you'll meet all the criteria for Terrafirma. And you also get a discount, which I'll talk about later. So next is, what property coverage does Terrafirma offer? and what's available. So Terrafirma covers conservation easements, preserves, aka fee owned or fee simple owned parcels, trail easements, access easements, and deeded restrictions. So for each one of these categories, the CEs, fee, trail, access, deeded restrictions, Terrafirma has an all or nothing requirement. So if you want to insure one conservation easement, you have to insure all of your conservation easements. You want to insure one of your fee simple parcels, you have to insure all of your fee simple parcels. But Terrafirma members can choose which categories they want to insure. So by insuring your conservation easements, you're not required to insure your fee simple parcels. You can choose to insure both of those and not insure your trail easements. Nationally, I think it's about somewhere in the 70 to 80% of Terrafirma members insure both their conservation easement and their fee simple parcel holdings collectively. But some Terrafirma members start off just insuring one category, like their conservation easements, and then maybe a year down the road decide, hey, maybe we should insure our fee simple parcels. So beyond those types of property, also the interest in land. So if you're the primary holder, co-holder, backup holder, third-party enforcer, or some other interest, those are insurable. Terrafirma does not provide third-party coverage. So if you have another co-holder or backup holder or third-party enforcer, they will have to separately apply to Terrafirma and get a policy to cover their interest in conserved parcels. But if you have an interest up there that's not like what you're seeing, feel free to reach out to me. Happy to talk if that's something that Terrafirma can insure. All right, everyone's favorite, premium registration and discounts. All right, so as a new Terrafirma member, there are two fees that you pay that first year. A one-time sliding scale registration fee, which is based on the number of parcels you initially insure. And number two is gross premium. For your second year and beyond, you will just owe gross premium. All right, and here's the very complicated underwriting formula Terrafirma uses to calculate premium. It is a flat rate amount per parcel. And this is the amount for 2027. But I want to call out two things about that gross premium. And this is a good but, is the special counting rules and various discounts. The special counting rules. Now, when you think about per parcel, you might be thinking, Tom must be talking about legal parcel. No. So depending upon how legal parcels are managed, if they have, for instance, for a conservation easement, if it's the same land owner or landowners, if the conservation easement is held by the same land trust or land trusts, plural, and if all of the conservation easements have this substantially similar permitted uses and restrictions, and you can meet those three criteria, then all of those legal parcels that meet those criteria can be counted as one for purposes of Terrafirma premium and coverage. So you may be insuring less parcels than you think. Terrafirma also offers many discounts. So in policy year 2026, I think Terrafirma members qualify for over $500,000 in discounts. So if you're an accredited land trust, that's $11 off. If you're not accredited, that's a best practices discount, $4. So regardless if you're accredited or not accredited, there's also a risk management discount you can apply, you can qualify for. So if you attend a qualifying risk management event, at Rally or the annual risk management webinar series or other events, that can give you another $1 off. And if you insure 250 or more parcels with Terrafirma, then there's a bulk discount of $3. And these can stack. So as an accredited member, you can accredited risk management bulk. As a non-accredited member, you can do best practices, risk management, and bulk. Another great thing about Terrafirma is Terrafirma allows for mid-year ads. So let's say that you acquire a parcel in June, which is sort of mid-year for Terrafirma. As soon as the closing happens and you have that legal interest in hand, you can go ahead and add that parcel to your policy. Mid-year ads are not prorated, so you will owe the full amount for that parcel, but it's a nice thing to have instead of waiting until the annual membership confirmation period to add your parcel. All right. Next thing is cost sharing policy limits. So let's say that you become a Terrafirma member and you file a claim with Terrafirma member with Terrafirma and it gets covered. So the first $5,000 of covered claim costs, that's called the deductible. Terrafirma also refer to it as the self-insured retention amount. But the $5,000 deductible for each covered claim must be paid by the land trust before Terrafirma's coverage begins. So again, that's why it's good to have legal defense reserves. They'll pay for things like a Terrafirma deductible. After that $5,000 deductible is paid, then Terrafirma's policy limits kick in. So Terrafirma has two types of policy limits. It has what's called a single claim policy limit and an aggregate claim policy limit. And let me use my little laser pointer here. So most Terrafirma members fall within this first row of having insured just one to 249 conserved parcels. So if you do that, you have a single claim limit of $500,000 and an aggregate claim of $500,000. Oh, all right. So the single claim policy limit means is that Terrafirma will pay up to $500,000 of covered claim costs for a single covered claim. The aggregate claim limit means for all those single claims that Terrafirma pays collectively, how much Terrafirma has paid out, Terrafirma will pay up to $500,000. So let me give you an example just to explain this aggregate. So let's say next policy year 2027, you get a covered claim and Terrafirma pays out $200,000. Now let's say under policy year 2027, you file a second claim and it gets covered. Terrafirma will only pay up to $300,000. Why? 200,000 plus 300,000 equals the aggregate claim policy limit of 500,000, or 500,000 minus 200,000, however the math works in your head. But, and this is another good but here, two notes. One is that there's no lifetime or coverage exclusive once limits are reached. If you reach Terrafirma's policy limits, congratulations. One of only a handful of claims that have done it. But there's no coverage exclusions, there's no nothing. Again, you get the same coverage, the same cost sharing, the same premium, the same ability to renew as any other Terrafirma member. And second is that the limits reset each policy year for those policy years covered claims. So let me explain this note here. And let's go back to that example. So again, policy year 2027, two covered claims. One is for $200,000, one is for $300,000. You've reached your aggregate claim policy limit. Let's say policy year 2028 rolls around and you file a claim with Terrafirma and it gets covered. Well, you have single and aggregate claim policy limits under your policy year 2028 reset to 500,000 and 500,000. So it's not like that 500,000 follows you for your life. It refers just to those years policy years covered claims. So while you may have hit the aggregate limit in policy year 2027, you have $500,000 coverage for policy year 2028 and for each succeeding policy year. Next is I just wanted to talk briefly just about land trust standards and practices. So land trust standards and practices are the technical and ethical guidelines for responsible operation of a land trust. They affirm the practices that secure long-lasting conservation of the public interest. Land trusts who implement them are stronger and their work long-lasting. While the standards are created by and for the land trust community, their impact has wider reach across the broader conservation community and the public. So the Alliance Land Trust and Conservation Practitioners drafted the first version back in 1989 at the urging of land trusts to identify certain best practices as to the surest way to secure lasting conservation. So they've been revised 4 times since then. The last revision was in 2017, almost 10 years ago. A lot has happened since then, and it's important for the standards to remain relevant to today's concerns. I do believe standard practice may be up for an update coming soon. But if you want, there's a hyperlink on this slide to see a copy of standards and practices on the Land Trust Alliance's resource center. And just to give you an example of what standards and practices looks like. So for instance, this is a standard 11C, conservation easement restriction monitoring. You'll see the little triangle there. So that denotes a Terrafirma enrollment prerequisite and accreditation indicator element. So if you're looking to enroll in Terrafirma or get accredited, keep in mind the symbols you see in standards and practices. Right. And the standards, are used by accreditation as the indicator elements. So it verifies that land trust is implementing the standards by reviewing the land trust materials on a subset of practices called indicator practices. So, for example, practice element 3D1 states that the board reviews and approves every land and conservation easement transaction unless it formally delegates that authority. And so what the Accreditation Commission does is it will review your board minutes to verify that that approval happened. And additionally, some practices are prerequisites to enrollment in Terrafirma, so like annual monitoring, baseline documentation, having sufficient legal reserves. But if you are interested to see where standards and practices overlap with Terrafirma eligibility, If you look at that resource on the Land Trust Alliances Resource Center, you see those little symbols that indicate a prerequisite for Terrafirma as well as for accreditation. So that was just sort of an overview of Terrafirma, eligibility, costs, and all that. So next, I just wanted to talk about some of the trends, the need to file claims, increasing challenges, and then some of the claim-related costs that we're seeing. So first, I just want to start off with some conservation resources and tips. So these are all hyperlinks. So just recently, I think within the past couple of months, the Conservation Defense Initiative that the Land Trust Alliance and the Land Trust Accreditation Commission published the 2025 trends briefing that highlights some of the trends that both entities are seeing. For conservation defense, that involves a little bit broader aspect of terra firma. It also involves some tax-related issues. But terra firma trends are definitely highlighted in this trends briefing, and it's a good resource for you and your board, stewardship personnel, if you want to know what's going on in the conservation defense world. There's a practical point about filing timely terra firma claims. I get asked a lot, hey, when should I file a claim? What sort of things are we looking at? This is the perfect document for you because it goes over some examples, some cases when you should be filing terra firma claims. But if in doubt, please, please, please file claims with terra firma. There's no financial penalty. File early, file often. We also have legal defense reserves calculator that's available on the Terra Firma website. We also have a hyperlink here to the Terra Firma charts webpage that's on the Terra Firma website. I just updated this with the latest and greatest charts that annually ARMS creates for Terra Firma's annual meeting. Goes over just high level about Terra Firma members, parcels insured, list of paid losses by state, fee versus CE claims data, looking at large claims covered, time to close, average cost, challenger types, challenge categories, what have you. A lot of great stuff in those charts. And then we have a best practices for complete stewardship documentation. So if you have questions about what type of documentation do we need for stewardship, this is a good resource for you. I also just want to just do a little plug for terabytes. Yes, I am that Tom Kester who writes terabytes and sends them to you periodically. These are hopefully little brief snippets about just sort of timely, evolving trends in the conservation defense world that we hope you find helpful and relevant. So just little some snippets, support and fund your stewardship team so they can do their job in full. We're seeing that, if you don't have the funding, if you don't have support, your stewardship team can't do their job. And that's when some issues can be negated by having your stewardship team supported and funded by your land trust and by your board. Another big one, oh boy, know and monitor property boundaries. We have to be able to ascertain and enforce all property boundaries. I think we've had multiple terabytes on this very topic, so lots of great info on that. Don't buy a lawsuit with your closing. I'm going to talk about that a little bit later, but there's a lot of times land trusts will call me up and say, hey, we're about to buy this property. It's got a litany of boundary disputes on it. Should we move forward with it? And we'll tear from the cover it. So as we'll get to later, no, Terra Firma likely will not cover those pre-existing and known issues for encroachment, coverable stuff. And the best time to resolve those issues is before closing. So don't buy a lawsuit with your closing. Avoid granting right-of-ways. We're seeing more and more requests from landowners that have right-of-ways, again, to create, modify, and expand right-of-ways. And it's something to be mindful of. There's great practical pointers on right-of-ways as well as terabytes on right-of-ways. And last but certainly not least, so again, please file Terra Firma claims and document. Some of the most successful claims that Terra Firma has are where the land trust has documented everything. The violation, they have maps, they have plats, they have emails, they have the communications, they have the photos, they have everything, and they can easily retrieve that and share it with their legal counsel. And that helps with trial strategy, that helps with the success of motions and the ultimate outcome of litigation and settlement. So when in doubt, document. If you do not have a document retention policy, I highly encourage you to consider creating one. There's resources on the Land Trust Alliance's Resource Center about document creation, retention, what have you. All right, this is a a fun chart that I like to share with folks. So this is a chart looking at all open covered claims by challenge category as of April 8th for 2026. So this is the latest one that I have available. We don't have a May members committee meeting, but typically we make these once a month. So what I mean here by open is that this is an active claim. So it's in some stage of resolution. And this is opposed to a closed claim, which is a resolved claim. So this claim might have just been covered last week. It might they might have not even spoken to their attorney yet. It might be in some stage, they might have filed a complaint, they might be responding to a complaint, this might be in some stage of discovery, it might be in pre-trial, they might be in trial, it might be an appeal, what have you. That's what we mean by open. Covered here means that the Terrafirma Claims Committee has accepted coverage for that claim and has set a reserve. And this is opposed to what we call a placeholder, also known as an on-hold claim, which is a claim filed by Terrafirma members just to give mere notice to Terrafirma of a potentially coverable situation. Now, most covered claims start out as placeholder claims. I just want to point that out. So again, we're not talking about placeholder claims, and that's the vast majority of Terrafirma claims. So when you hit that 4,100, about 3,800 of those are placeholder claims. And so again, this is just open covered claims at this very moment as of April 8th. So this is again a snapshot in time of what Terrafirma's covered. So you'll see here that the top three biggest ones are boundary and access, vegetation cutting, and structures and improvements. So if you remember back to that slide where I brought up those challenge categories, and remember those sort of issues, that's what Terrafirma is covering. So year over year, boundary and access, vegetation cutting, structures and improvements are generally 1, 2, and 3 in terms of being the biggest open cover claims in that year. They'll jockey back and forth as to who's first, who's second, who's third, but generally year over year, that's what we see as 1, 2, and 3. Now, the other challenge categories here, topography changes, division, partition, extinguishment, water rights, condemnation, dumping, adverse possession. There's more volatility to how many claims there'll be in a given year. So there's more volatility in what placement they are. I will say we are seeing a trend where topography changes is sitting there at fourth place. Sometimes it has moved up into the top 3. But generally there's more volatility down there. So extinguishment might be up, division might go down, what have you. Oh, and also if you were to look at placeholder claims, again, those 3,800 claims, you would see roughly sort of the same distribution where structures, improvement, vegetation cutting, boundary access are going to be the top 3. There's probably a lot more volatility year over year as to for the other categories where the relative position is, but generally that would sort of be the snapshot of placeholder claims as well. So again, I'm going to probably bring this up multiple times because this is my job, is just to get people to file claims with Terrafirma. Remember, filing one or more claims with Terrafirma will not affect your premium, cost sharing, won't affect your coverage or policy limits. It will still permit you to renew your Terrafirma policy. It will not prevent you from working directly with the landowner or neighbor on amicable resolution. It will not require you to seek a coverage determination. You, the land trust, get to choose when to close the claim. So again, what this means, please file claims with Terrafirma and file timely claims with Terrafirma as well. Okay. And I say that because I would next want to go into claim denials. So the 3 main reasons that Terrafirma sees claim denials is because it's one, excluded from coverage. So if you are a Terrafirma member, or when you do become a Terrafirma member, please examine section 3 of your policy. Those are excluded provisions. Second reason for a claim denial is that it's a pre-existing issue. It happened before the policy's retroactive date. And number 3, it's untimely filed. So the date of when the issue was first known and when the claim was filed is not in the same policy year. Those 2 things happened in different policy years. That's an untimely filed claim. And the reason why I point out to please file claims with Terrafirma and file timely claims is that the most recent trend that we're seeing is that untimely filed claims is the #1 claim denial reason. So please, if you are a Terrafirma member, timely file claims. File it at the first instance when you know the claim, even if it's trivial, de minimis, small, you don't think it's going to materialize. File your claim. Again, there's no downside to filing claims, so please file a claim. I have members that call me up, call Leslie Ratley Beach, my boss, up, and they say, here's the fact scenario. Should we file a claim? I've spoken to Leslie. Both of us can't think of a time where we have not said file a claim. So just go ahead and file a claim with Terrafirma. And just to give you an idea, so this is sort of breakdown over the past couple of years of percent of claims denied, just pre-existing untimely excluded, those three categories in the percent. And you'll see here that untimely filed is the bulk of the reason why a claim is denied. So please, if you are a Terrafirma member, again, I was on the broken record, please file timely claims with Terrafirma. All right, challenges and challengers. So in the last decade, Terrafirma has seen just dramatic increases in covered claims and in all claims. And what's causing this increased claim filing trend? Well, there's two things. One is there's educational outreach. It's me coming to to events like this, saying, please, please, please file claims. And members are taking that into consideration and are actually doing that. They're filing more claims. That's a good thing. So some of this claims volume is that educational outreach. Land trusts understand that they need to file claims at the first instance that they learn of an issue to preserve the timeliness of their claim. But that doesn't explain it all. And there's another side to this increased claim filing trend, which is that we've seen affluent, stubborn landowners who want things done their way. And that has driven more claims. And this is not a great trend that we're seeing. This has been particularly pronounced since late 2019, particularly during the pandemic, where we've seen a lot more claim filings related. And we see that there's these affluent, stubborn landowners. It's Connecticut. I'm sure you have your own share of affluent, stubborn landowners. And they want things done their way. And they think that they can just pay to make the problem go away. And they're throwing more spaghetti against the wall, trying to, get things done their way. They're not willing to settle early on, so it's requiring more time and energy for land trust attorneys and for Terrafirma to resolve these claims, to filing litigation. They're going through all the hoops to get to settlement instead of getting it earlier on, which we did see, prior to 2019, that was a little bit easier to get to settlement. But now it is a little bit harder, given recent trends. Like I said, opposing parties are less willing to settle earlier on and more using counterclaims, inflated monetary damages, and endless court-related tactics to drive up costs and delay enforcement. Came out in the recent Terabyte about counterclaims. So when landowners point the finger back at your board and say, you, the land trust, allowed us to do this, or you permitted this, or you're not following your conservation easement, and they point the finger back at the land trust, this is a court tactic. And this also is a situation that can kick in your directors and officers coverage. So just be wary, that's more and more common counterclaim tactic that we're seeing. We're also just seeing some endless court delay tactics just to drive up costs and delay enforcement. They're trying to sweat land trusts out. They can delay. They're trying to get settlement or even to make the problem go away. So we are seeing that as a more recent trend by opposing parties. So talking about just the challengers themselves, successor owners are the largest category of challengers, both placeholder and covered claims. Third-party trespassers and original grantors have increased dramatically over time. Original owner disputes cost 30% more to resolve than successor owner disputes. And this sort of is a breakdown of number of claims, those are covered claims, percentage of placeholder claim, or percentage, I think, of covered claims. Sorry, percentage of claims is for all claims. And then percentage of covered claims, total cost of claims, and the average per claim. If you can believe this, over time, original owner disputes have risen. And Terrafirma now has original owners who are bringing extinguishment claims, challenging the very validity of the very conservation easements they set up. Think about that. That's a crazy trend we're seeing. But original owners are beginning to fight back against the conservation easements they helped set up. So that's a trend we didn't see from 14 years ago. So that's all the data I've shown you there. That's sort of a national trend, looking at what Terrafirma sees nationally. So let me talk specifically about some Connecticut claim stats. So this data is actually as of claim filings as of May 18th. This does include all claims data from policy year 2025, which we just got in. So there are 27 Connecticut Land Trust members as of policy year 2026. And they insure almost 1,400 parcels, a little over 55,000 acres. So since March of 2013, 60 claims have been filed by Connecticut Terrafirma members. And statistic is that 83% of those claims were filed after January 1st, 2020. So remember back to that slide about why we're seeing an increasing trend. Education and stubborn landowners. And this right here goes to help support that really the pandemic has caused a major influx of claim filing. Again, some of it is from education, some of it is from those stubborn landowners. But that's really is sort of a sobering statistic that 83% of claims, and this is not unique to Connecticut either. If I was to pull a random state, I would probably see a really large statistic, like probably well over 50, 60% of claims in that state have been filed since January 1st of 2020. So out of those 60 claims, 12 of those have been covered since March of 2013. So what's really interesting is that 20% of all Connecticut claims are covered. That's greater than the Terrafirma national average, about 10%. So that right there that would give me pause that there's a greater chance that a placeholder claim filed by Connecticut Land Trust will ultimately need to seek coverage because it develops into a situation where you need to have an attorney involved or litigation has been started. So that was an interesting trend. I don't know if I've seen that for other states. I haven't looked at all the states, but that statistic in particular hasn't popped out to me. So Terrafirma has paid in total $175,678.88 on total Connecticut covered claim costs since March of 2013. And if you exclude $0 claims from that, Terrafirma pays on average about $24,096.98 per Connecticut covered claim. And remember, this is after the member pays $5,000 deductible. So if you're not a Terrafirma member, you're looking more at the $29,000 range. What's also interesting is that fee simple parcels are for the 12 covered claims. So 1/3 of Connecticut covered claims involve fee simple parcels. So for those of you out there that believe that fee simple ownership is some sort of magical shield to litigation, that you could never ever have a challenge to conservation purposes, your claim status says something different. Chainsaws and bulldozers and irate neighbors do not care about your legal interests. They don't do title searches before, they just do what they want. So that is a really interesting statistic that 1/3 of Connecticut covered claims involve fee simple parcels. And just to give you a comparison, nationally, excluding $0 claims, Terrafirma pays about a little over $56,000 on average per covered claim. So just 2 points on that sort of average claim cost for Connecticut versus national. Connecticut covered claims are relatively young, and more costs are going to be incurred in the future. As I said, 83% of claims were filed after January 1st, 2020. It takes some time for a placeholder claim to develop potentially into a covered claim, and then for a covered claim to ultimately incur its final ultimate cost. So that average for Connecticut is going to go up. I can guarantee it, just because of the relatively young nature of some of the covered claims. But also it's going to go up, as well as national average. Both those averages are going to go up because year over year, we're seeing increasing costs. This is just because there's more covered claims, because attorneys' fees and costs are going up, more expert witnesses, more complex nature of litigation is driving up those costs year over year. I do this presentation a lot, and I will tell you that Terrafirma national average figure goes up every single time I revise this chart. So just keep that in mind. So that, again, don't treat that number as static. It is dynamic. It is going to go up. So if I do this presentation next year, that number definitely will go up. So Terrafirma claim stats. Let me just continue talking about challenger types. So again, 3 challenger types: original owners, successor owners, third-party challengers, third parties, and trespassers. So when a claim comes in, it gets put into one of those 3 categories here. So for Connecticut claims, 33 of those claims are third-party trespassers. So that's about 55%. Successor owners, 25 Connecticut claims fall within that challenger category. So that represents about 42% of all Connecticut claims. And then there's 2 original owner claims. So that represents 3% of all Connecticut claims. So you'll see they're nationally, Connecticut's online with third-party trespassers. You have a real overweight to successor owners, 42% versus nationally at 20%, and original owners, 3% Connecticut, nationally 21%. I will get to this point later on. And I'll talk about that a little bit later about why we're seeing this. And then by challenge category. So again, when a claim comes in, it gets assigned a challenge category. Remember that chart I showed you with all the green leaves across and all the examples of what goes into those challenge categories. So here's a breakdown of all Connecticut claims by challenge category. So the top three: vegetation cutting, structures improvements, boundary and access. So Connecticut challenge category wise is in line with what Terrafirma sees nationally. And then for the other three: topography challenges, dumping, condemnation. Again, there's more volatility in what the other sort of claims may be. So this year's topography, dumping, condemnation. Next year, who knows what it could be. There's a lot more volatility again. So I don't really see anything that pops out to me, sort of as not in line with national trends, from Connecticut's claims. So earlier today, I met with my boss, Leslie Ratley Beach. For those who don't know her, Leslie is the national coordinating attorney. She's vice president of arms. She's also director of the Conservation Defense Initiative at the Land Trust Alliance. So her job is to handle the claim side of Terra Firma. And for those of you who have covered claims or have filed claims or have asked about claims, most likely you've been in contact with Leslie. And so I asked her, Leslie, is there anything you want me to pass along to Connecticut Land Trust about the Connecticut claims that we've been seeing? The first thing she wanted to tell you about was just original owner turnover. So there's more claims and more serious claims come from successor owners. And Connecticut Land Trusts are on the forefront of a generational land transfer event. And she said, consider adding more to legal defense funds and preparing for the upcoming original owner turnover wave. Well, I can go put my laser pointer on. So again, 55% for third party, 55. But here, 42% of Connecticut claims are successor owners versus national 28. Original owners 3% versus 21. This is a tsunami. As original owners become successor owners, again, be prepared to see claims, be prepared to file claims for successor owners, because typically successor owners are the ones that challenge conservation easements a lot more than original owners. And as we're seeing this generational transfer, Connecticut Land Trust being older and more established, and just looking at who your property owners are, just be prepared for that. And, take the time and energy to think about how you're going to deal with potential successor owner related challenges and have sufficient legal reserves. Second thing is just the high value properties in overseas. So this is no shock to all of you. The Connecticut high value property market, it's driving boundary, vegetation, housing division challenges. Landowners have funds to challenge land trust actions, and as well as challenging when a land trust disapproves of a landowner's plans. So again, you have affluent, stubborn landowners. What's complicating some of this is that Connecticut easements are older and sometimes vaguely written with numerous ambiguities. And successor owners have been trying to exploit those ambiguities. It's expensive to defend and deflect these ambiguity-related challenges. It makes settlement all the more difficult to reach, and the settlement outcomes are less than one might expect. You might be thinking, well, clearly the conservation easement says this, but because of those ambiguities, because of the vagueness, that can complicate things when it comes to settlements and when it comes to getting the resolution that you hoped for. So that's something that some of you will have to deal with. And you might have to fund some more legal defense reserves for certain properties, and also consider, making sure you keep up to date with the latest and greatest conservation easement drafting language. The Land Trust Alliance Resource Center has lots of resources on conservation easement, land management plan drafting. Third is pre-existing encroachments. So we're seeing Terrafirma seeing pre-existing encroachments from Connecticut Land Trust. Some Connecticut Land Trusts are expecting that Terrafirma will cover pre-existing encroachments when these encroachments are even noted in the chain of title. Terrafirma does not cover pre-acquisition known issues. I would refer you to section 4.7.1.4 of your policy and section 3.12. Also keep in mind that a verbal promise to resolve is not good enough. You've got to get it fixed. You've got to get it into the chain of title. The greatest leverage a land trust has to negotiate an encroachment resolution is pre-closing. It's not afterwards. You have such diminished leverage negotiating power afterwards. After the money's been handed, after the landowner runs away, you got very little to help you with. So don't buy lawsuits with your closing. All right. My last part here is just considerations for relying on statutory provisions for attorney fee recovery. I want to just say that this is not legal advice. I'm not your attorney. This is intended to create an attorney-client relationship. The information that I'm going to present is just for general educational purpose only. Please do not rely upon it as legal advice. I highly encourage you to speak with a licensed attorney in your jurisdiction if you have questions about anything in this presentation or in this section. Okay. So certain states, Connecticut is one of them, have statutes that permit attorney fee recovery. And these statutes may give discretion to courts about whether to award attorney's fees and or if it does want to award attorney's fees, how much to award. Some statutes don't provide for attorney fee recovery. And it's really important that you speak with an attorney in your jurisdiction to understand, what statutes provide for attorney fee recovery, what are the contours of these laws, how and when they may come into play. So in the United States, almost all courts follow what's called the American rule. That is, there's an assumption that is that each side pays their respective attorney's fees, and the prevailing litigant is ordinarily not entitled to collect attorney's fees from the losing side, absent express authorization. That express authorization typically comes from statutory, contractual, common law areas or bases. So to overcome the American rule is generally a high bar. Some of these statutes allow the court to consider many factors to whether or not a land trust has reached that high bar. Some of the factors that may be considered include if you only win some of the arguments and by how much. The other side has some good points for why they did what they did. The CE or land management plan is vague or subject to different interpretation or omits critical information. And the land trust said or did something that could be interpreted as allowing or acquiescing to the unpermitted activity. So if any of those factors come up and they could be considered, the court might say, the land trust hasn't reached that high bar to overcome the American rule. And so thus they are not entitled to overcome it. They may not even be considered the prevailing party, which I'll get to. And if you're not the prevailing party, that also, there's factors included for prevailing party analysis. And some of these may also become for that. So you may not be seen as the prevailing party, and the statute may say only the prevailing party gets it. Your very own conservation easement may say the prevailing party is entitled to attorney's fees and costs. So those are things just to keep in mind. Again, this is not this is an exhaustive list. This is just a couple examples for factors that courts consider. Like I say, some statutory recovery provisions only apply when a court adjudicates. So this is via bench or jury trial. About 90–95% of civil litigation nationally is amicably resolved through settlements, and statutory provisions may not control or be applicable in voluntary settlement situations. Very importantly is where recovery provisions could be applicable in settlement. Your conservation easement or land management plan says that the land trust is entitled to recover its attorney's fees and costs in enforcement action. So enforcement may not have the prevailing party requirement. It may not even need a court action. But this is a bad but. From experience, one of the critical settlement points is the opposing party tells the land trust, you must agree to waive your demand that we pay your attorney's fees. And if you don't agree to that, deal is off and we'll see you in court. This is a very common situation where Terrafirma members ask to forgo collecting their attorney's fees and costs from the other side in order for settlement to occur. And per Terrafirma policy, Terrafirma has to agree to settlement. So that's why Terrafirma is involved in these things. This is a very common tactic. The other side will agree. And you might think, well, why are attorney fee costs a sticking point in settlement? Well, the restoration cost, the cost to fix the issue, and future costs like monitoring, compliance, stewardship, that might be easily agreed to. They might say, okay, you know what, we moved some earth, we planted a tree, all right, we'll reseed, we'll remove the tree. But those restoration costs may be significantly less than the attorney's land trust attorney fees, and by like magnitudes. So while the restoration may be thousands of dollars, the attorney fees are tens of thousands of dollars. So that line item in particular might be the biggest thing that the opposing parties' clients have to pay. And so that becomes a sticking point in settlement. The other reason why it becomes a sticking point is that at trial, there's a chance the court may not award attorney's fees because, again, of that high bar it takes to get that award by virtue of the law, the evidence, the circumstances, even the judge's very own disposition. How much do they like land trust? How much do they, think that your side, is owed attorney's fees and costs get covered by the opposing side? And attorneys know this, so that's why, that becomes another sticking point in trial. Again, depending upon your state statute and case law, expert witnesses may not be recoverable under attorney fee provision. So your land trust could be on the hook for these costs, and expert witnesses can be expensive. So I just wanted to just give you two examples. So surveying firm was needed for a covered claim. They provided survey and expert witness services. Their invoice was over $27,000 from fall of 2024. Another covered claim involved a wetlands restoration firm. They provided assessment design, restoration expert witness services, and their invoice was over $37,000. That's from June of last year. I don't want to come off as saying that that Connecticut has these statutory provisions are bad. It's great that Connecticut has statutory provisions to recover attorney's fees in certain circumstances. This is a great thing. More states should have these provisions in place. It's another tool in the tool chest that the land trust community can use to recover attorney fees costs. In case the conservation easement doesn't work, in case the land management plan is not working, you can fall back on these statutory provisions. But what I've discussed is to use a metaphor. It's like your land trust rolling multiple dice and hoping each die lands a certain way. That the facts, that the law, that the judge, that the evidence, that all of this lands in a certain way. And it's possible, but there's a lot of uncertainty. And I would say just have realistic expectations for when and how recovery provisions may apply and when they won't apply. And this might be a good time to speak to a licensed attorney in your jurisdiction and spend some time to understand, hey, for these Connecticut statutes, when and how do they apply? What are the contours? When haven't they worked? What are things we should be mindful of about them? Okay. Because, if the statutory provision doesn't apply to the challenge of experience, you win by a little or only some, you settle, you need that expert witness, you lose. Terrafirma can cover the bill. And that's, I think, real peace of mind that Terrafirma offers is that, win or lose, whether you need the expensive expert, all the uncertainties that happen in litigation, Terrafirma stands ready to help defend its members and conserve their conservation in perpetuity. So with that, I'm seeing I'm at 1 o'clock, so I did my hour. Ugh, a lot of talking. But now I wanted just to move to the Q&A. But before I do, I also just wanted to say I have two others at the end of the slide. I also have my contact information. I also have Shelly's contact information here at the end of the slide deck. So with that, I'm going to turn the mic over to, I'm guessing, Ricky, do you want to take it over and see if there's any questions?
Yeah, so we got one multi-part question right off the bat. How do the reimbursements work? Direct payment to attorneys or others? You send the invoices and you pay the land trust? Also, do you play a role in picking professionals, or is that up to the land trust?
So a lot of great questions in there, John. So how do reimbursements work? Typically what happens is, so for the cover claim, the attorney will directly bill Terrafirma, or what they do is they'll send a bill to the land trust. The land trust then turns around and sends the bill to Terrafirma, and then Terrafirma will process the invoice and directly pay the attorney. Occasionally, if let's say the land trust were to pay for something that's coverable, there are sometimes situations where Terrafirma does reimburse the land trust. But typically, the attorney's invoices are directly sent to Terrafirma, and we pick up the tab. So the land trust doesn't even need to be involved. Sometimes, just based upon practice, the law firm will send the invoice directly to their client, being the land trust, and then the land trust literally just turns around and forwards it to Terrafirma. And what role do you play in picking professionals, or is that up to the land trust? So some liability insurers have what's called panel counsel, whereby the insurance company has prearranged contractual arrangements with certain law firms that the insured has to use, and it has to pick from. Because of ethical and other reasons why a law firm might be conflicted out. Typically, there's a choice, but that's the only lawyers or law firms that the insured can use. Terrafirma does not use panel counsel. So the land trust is free to pick an attorney that they want to have represent the land trust. If there's two parts to the if. Number one, the land trust agrees to, or sorry, the attorney agrees to Terrafirma's attorney payment plan. And two is that the attorney meets Terrafirma's experiential requirements. So again, we want to have attorneys that have been in court, have handled these type of issues. And we also want to have attorneys that agree to the payment plan to help keep costs down for other Terrafirma members and keep premium low. Assuming they meet those two requirements, then you're free to use whatever attorney you would like. If you don't have a relationship with attorney or don't know of attorney, uh, ARMS, Terrafirma are happy to provide you with suggested lists of attorneys who might be good for your land trust and for your covered claim.
I think on that note as well, CLCC is currently working on compiling a list of attorneys to add to our service provider directory. So you can also reach out to us. Anyone else want to throw any questions in the chat?